on. Hello and welcome everyone. I'm Molly Rosen with the 4As, and welcome to today's Business as Unusual webinar, Emerging Laws Governing Agencies' Use of AI. Most agencies and their clients are now using generative AI, at least for some activities, even if just internally. And while a lot has been said and written about the legal and ethical issues associated with generative AI, and much still remains to be seen, new laws in the US, as well as new laws abroad, are starting to build a web of obligations and prohibitions that will impact all agencies and marketers. Therefore, I'm very glad to have with me today Eric Prager, partner at Venable LLP, and Heather West, Senior Director of Cybersecurity and Privacy Services at Venable, both of whom will provide valuable insight to navigate this exciting yet challenging new frontier. A few housekeeping notes before we get started. We are recording today's session and will make it available on the 4A's website. Additionally, we will have time at the end for audience questions, so please be sure to use the Q&A feature in your Zoom toolbar to submit your questions. And with that, Heather and Eric, I'd like to thank you both for being with us today, and I'll turn it over to you.
Thanks very much, Molly. It's a pleasure to be here. Thank you for inviting us. We appreciate it. So this presentation is in the nature of a follow-on to an earlier presentation that the 4As organized. That earlier presentation highlighted some of the high-level issues that AI gives rise to in the context of agency practice, things like protectability of output under copyright and patent law, some insurance issues, some confidentiality issues. Now, as the landscape has continued to evolve, we're starting to see actually issued legislation, including the EU AI Act, some firm statements of policy like the executive order coming out of the Biden administration that's starting to set the table, and some state laws that are starting to come into force and others that are still under negotiation. So as those laws are starting to evolve, we have some additional things that we can start to say and some additional things that agencies can start to think about in terms of guiding their conduct and managing their risk. So we will kick it off with my colleague Heather West, getting us up to date, taking us through some of those different legislative frameworks. Heather?
Great, thanks, Eric. Happy to be here. So we're going to do a quick tour through some of these emerging laws, but I'll tee it up now. We are happy to take questions after this. I think the Q&A tool is probably working. Molly's nodding, so that's good. And if you want to put any questions in there, we can make sure that we address them. This is all moving very quickly. Artificial intelligence is really one of those really hot topics that every legislator wants to think about in the same way that every agency is thinking about using AI. So we'll start with the US Congress. The US Congress has a number of emerging themes that are worth noting. And this is in the context of a number of hearings and task forces and working groups, and just a lot of exploration around the idea and the technology of artificial intelligence, both generative AI as well as kind of the broader set of AI technologies and uses. But the thing that is very good to know in this context is that these themes will be a bit. We're not expecting any major congressional legislation and movement this year, but Congress is very, very clearly building up towards the ability to write reasonable AI legislation next year. So there's a lot of discussion around regulation of the use of AI in robocalls and deepfakes. We've already seen AI-generated deepfakes used in, for example, an election context. And legislators are paying a lot of attention to that. They're very worried about what we are calling now synthetic content, and that is content that has been significantly, materially, some Mad Libs word, altered through the use of AI or other digital tools. And later on in this list, we're thinking about that content provenance and labeling for synthetic content, even outside of the context of robocalls and deepfakes. But synthetic content is a good one to think about because a chatbot creates synthetic content, or image generator that takes an input and then gives you something graphical, that's synthetic content. And so to the extent that Congress is thinking about synthetic content, they are often not thinking about the broad scope of synthetic content, but you're going to need to. Congress is also thinking about how to create transparency for users. And so that's, for example, when you're on a customer service website and you're chatting with a customer service agent, Congress largely feels that you have a right to know whether that's a bot. And there are some explorations in the advertising and marketing industry of some similar uses of generative AI. Um, there's specific labeling around political ads and transparency around generated political ads. That one may actually move this year, just based on the timing of the election. There are also themes around the idea that the US government can facilitate innovation in AI, thinking about funding research and development, putting grants out, easing the federal procurement and acquisition of AI systems so that the US government can use AI. And we'll talk a little bit more about that on a later slide. But my big takeaway when it comes to thinking about how AI is approaching Congress is that they're still figuring it out. Senator Schumer actually announced that they are starting to put pen to paper on AI legislation in the Senate. There's been a number of proposals in the House, but we're really at this thematic stage. Eric, any thoughts or next slide? All right. Oh, go ahead.
I was saying ready for the next slide.
Excellent. And as always, getting bested by the mute button. So the Federal Trade Commission obviously has been paying a lot of attention to artificial intelligence within the context of its existing work, precedent, and jurisdiction. And they've put out a few policy statements or blog posts that I think are worth knowing about. One is around privacy policies and terms of service. The FTC has noticed that some companies are looking to change their privacy policy, terms of service, or other legal documents to change the way that they can use data. And what that looks like is maybe you want to collect some data and put it into an AI system in a way that you didn't 5 years ago. The FTC is paying a lot of attention to the kinds of changes that are made to enable using data with AI. And they're very keen on the idea that they might find folks who are changing the way that they're using data or using data in ways that they didn't really get consent for. And so they've been putting out a number of speeches and a number of policy statements to that effect. So to the extent that you have privacy policies, it is worth thinking through how it already applies to the data and whether you're making any changes that retroactively are attempting to change anything. Data licensing is another hot topic. The FTC is thinking about inquiries into the sale, licensing, and sharing of user-generated content in particular, but also other data with third parties to train AI models. There have been a few examples of this, of large social media sites inking deals where they can take that user-generated content and sell it or license it to someone creating a large language model and who would then use it as training. And similarly, the FTC is looking at that with a little bit of skepticism because the idea that data licensing is this new untapped source of revenue is one piece of the puzzle, but the other piece is there's probably some expectations around that, how that data would be used. So we haven't seen any enforcements or settlements in that space specifically over the last few months, but the FTC has clearly signaled that they are paying attention. And they are also paying a lot of attention to mergers and acquisitions. And so they're all told, all three of these things put together just indicate how much the FTC is thinking about this data use and the different ways that data might be combined and that folks might get access to it. And the FTC has issued 6B orders to understand the impact of some of these partnerships, some of these investments, in terms of how the AI ecosystem grows. So, Eric, your thoughts?
I think that's a
Okay.
thorough accounting.
Excellent.
Shall we move on to the executive order?
Yes. So in October, the administration released an executive order on the safe, secure, and trustworthy development and use of artificial intelligence. We will go through it really quickly here, but a thing to know is this is 111 pages executive order with well over 100 actions for federal entities, agencies, organizations. And it signals a comprehensive approach by the U.S. government, by the administration, so the executive branch, to approaching artificial intelligence use for themselves, how they're regulating artificial intelligence as regulatory agencies, and how they want to help facilitate and guide the industry developing, deploying, and using AI going forward. Two pieces of note. The Copyright Office is actively working on a study around copyright issues, and that's because there's a lack of clarity around what the new paradigm of taking inputs and creating outputs from AI means. Is it appropriate to use copyrighted data in training these large language models? Is it appropriate to use copyrighted data or licensed data or anything else as an input into a generative AI system? And can you then claim ownership and intellectual property ownership of that content when it comes out? That is somewhere that has been notably a topic of a lot of conversation. There's a little bit of court precedent there, but the Copyright Office is actively looking into it. They've taken some comments. I'm frankly incredibly intrigued to see where they land on this because it's a really hard one. USPTO, the Patent and Trademark Office, as well as the Copyright Office, are also in the follow-up of that going to issue recommendations around executive actions to address these topics. And what those look like remains to be seen. But my guess is that it will impact this ecosystem in significant ways because we're talking about some of the content and content ownership. If you're creating something that using AI that you would like to have copyright protections for, you're going to need to pay some attention here. The other piece of this that I wanted to flag is the synthetic content piece that I started talking about in congressional actions. NIST has published a draft paper called Reducing Risks Posed by Synthetic Content. And this is an incredibly nerdy, but really thorough examination of the technologies that are in place to authenticate content, to track content provenance. And so those two are, is the content real? Where did it come from? Is it credible? Is there a way to label it that says, this is from the White House versus this is someone using a White House logo? Or, thinking about ways to label synthetic content that in fact are more robust than just like a watermark. So these kind of existing standards, tools, and methods are the subject of this report. And they are going to use this report once it's finalized in, I believe, July, to develop guidance for federal government use of these technologies, and very specifically to enable the ability of credible government information to be labeled as credible government information that it came from the government. So worth paying attention to there. Eric, next slide.
Yeah, this is actually one where I do have a couple of thoughts with respect to the copyright and patent issues. So while some positions have already been taken by the Copyright Office and the Patent and Trademark Office, and while additional recommendations are going to be forthcoming, there's already litigation relating to the positions that the Copyright Office and Patent Office have taken. Interested individuals have sued those offices, arguing that the policies that a human must be involved to create copyrightable subject matter or patentable inventions are not supported by the Copyright Act and the Patent Act, and that's working its way through the courts. These recommendations also won't have the force of law. So while there will be some expressed viewpoints and maybe some recommendations for interim executive action while litigation is pending, I think it's pretty clear to the IP lawyers that this is going to need to make its way to the Supreme Court before we're really going to know the answers to these things, unless Congress steps in and amends the Copyright Act or the Patent Act to cover these issues expressly. Onward on our slides.
Yes, please. So if you can tell, right now we're talking a lot about a lot of emerging things, and we don't have a ton of certainty on them. But hopefully this is flagging the things to pay attention to. And we'll move into now some of the things that we will need to pay attention to, that they're more certain. The states are proposing many laws around AI. I think at one point we were seeing something like 50 different proposals a week. Now, state legislatures are kind of winding down. Some of these have been passed, but they also have some similar themes to what Congress is thinking about. There's a lot of discussion around discrimination and high impact decision making. You may have seen that Colorado just passed requirements around consumer protections, including risk management, impact assessments, discrimination, some transparency rules, and it's kind of being hailed as a first in the nation comprehensive regulation for private sector AI. California is thinking about a number of bills, some of which are comprehensive and some of which are not. And then the California Privacy Protection Agency is working to regulate automated decision-making. That particular proceeding is underway, but may take some time to actually settle out. But they are looking at a number of rules that would be reasonably strict and more similar to some of the European rules around how you use automated decision-making. Now, I think there's also some skepticism within the folks debating this that these rules will be effective or, usable. And so that is an ongoing topic of discussion in California. There are also proposals around content provenance. So where did this come from? How do I know? Clarification that existing consumer protections apply. And that is a theme across all of these actors, by the way. That folks are looking to dispel the idea that existing rules don't apply. They absolutely, technology neutral rules do apply to AI, and so they're making that extra clear. Utah and Massachusetts both have legislation and advisories emphasizing this. They're not the only ones, but if we were to list every state that proposed that piece, it'd be a fairly long list. A number of states are thinking about transparency for users when they're interacting with an AI system. That one in particular is very interesting. Some of those proposals are very high level and would capture a lot of the different kind of automated decision-making technologies that are in use today and might have a fairly overwhelming impact around, on par with the cookie banner that just pops up on every website and says, hey, we're using cookies. Very similar, I think every website would pop up and say, hey, we're using AI. And certainly every programmatic ad would say, hello, I'm here because of AI. And so folks have realized that that might not be the best approach and are rethinking what that threshold might be for that kind of transparency. Last but not least, there's some regulations being proposed and passed around voice cloning and audio deepfakes. Again, this goes to some of the robocalls questions. Tennessee's Elvis Act, which layers on to a relatively unique state intellectual property regime, was the first to pass and may prove to be a model either for other states or federal legislation, but that remains to be seen. Eric, thank you. So let's move further into the realm of things we know you need to pay attention to. The European Union earlier this year passed the AI Act. Now, if you thought 111 pages of the executive order was long, the AI Act is longer. It's 200 some. I have a track changes version printed out in my office. It's 900 pages long. So this was the topic of a lot of discussion and a lot of development, and then some last minute additions to kind of cover generative AI as the new emergent and popular AI technology. But the basics for the AI Act, it covers a wide range of AI, and the definitions are incredibly broad. Many of the definitions in these proposals we've talked about today are very broad. They're based on an OECD definition that really sweeps in most digital systems. And so in doing that, they categorize these AI systems at 4 risk levels. One is unacceptable risk, and so that's prohibited. And so that's something like broad use or ubiquitous use of facial recognition scanning. It also has to do with manipulation. So AI systems that are intended to manipulate or change people's minds are considered unacceptable risk. High risk systems are really the ones that the AI Act seeks to regulate. That includes targeted advertising, and particularly advertising that might be discriminatory, in a very broad definition of discriminatory, and requires risk management, technical documentation, human oversight, and the ability for a human to intervene, and a data governance program. I will note that the list of kind of high risk AI systems includes other kinds of systems that I would consider higher risk than targeted advertising, but the European Commission does look fairly skeptically, as you all probably know, on some kinds of ad targeting, and they are very concerned that particular kinds of advertising might unduly impact someone's life, that a system might be discriminatory, that it might have bias. And so they included targeted advertising as potentially a high-risk system. The other 2 categories under the AI Act are limited risk and minimal risk. Those are not particularly highly regulated. There's some transparency requirements around limited risk systems, and actually the AI Act doesn't regulate minimal risk systems. And their vision is actually that this is a pyramid, that there's a very few number of systems that are considered unacceptable risk, and a lot of systems that are considered minimal risk. But of course, we don't know how that's going to work in practice. This law will go in force later this year. They're thinking May or June, and then enforcement will begin 2 years later. So you've got 2 years and change to think about how to comply. And you do need to comply if you're targeting EU customers. And so it doesn't matter where you're based. If you're targeting EU customers, the EU AI Act will apply. And that means that your AI generated content would need to be labeled. AI users, that's you, have to demonstrate that their models, training data, and outputs are free from bias, or in some meaningful way you have done your due diligence there. And they've been very clear that GDPR still applies to data collected or used with AI models. Happy to talk about that one a little bit more, but it's a big one. It's a very thorough law, and I actually think that the European Commission did a reasonably good job of discussing it and targeting it in the way that they intend to. That doesn't mean it's going to be easy to comply with. So, Eric?
That's great. So I think at this point we might sort of transition into how agencies might start to think about how these laws are going to affect their day-to-day businesses. And I think one of the ways that this comes to a head sooner than later is in the contracts that agencies have with their clients. I think we're some ways out from a time when enforcement agencies are coming to bear on either advertising agencies or their clients, but advertising agencies are going to need to govern their conduct long before we get to the enforcement stage with any regulators. So, the kinds of things that make me nervous when I'm thinking about, if I'm negotiating an agency agreement, and thinking about how AI regulation relates to that or may relate to that, are provisions that in earlier times may have seemed perhaps unassuming or lower risk, but take on a different risk profile now. Common reps and warranties, like agency represents that it'll comply with all laws. Okay, that's great. You need to know what all the laws are before you are able to do that. And on some level, I certainly have heard lawyers say, well, I have to comply with the law anyway, so this isn't that big a deal. Sure, it gives my counterparty an opportunity to terminate the agreement, and maybe that's a little bit different risk profile than an enforcer coming after me. But because of the breadth of some of these laws and the still in process nature of them, something like this becomes a lot harder to comply with. And while you may not be able to avoid making a rep and warranty like this, it's the sort of thing where I think it counsels being more proactive in learning what the laws are and taking some steps to comply. I think that some action is going to be needed to stay up to date on these things, and to integrate the requirements that these laws impose into business practices. Another that gives me heartburn, in the last year, since generative AI has become so popular with agencies, is agency represents and warrants that all deliverables will be fully and exclusively owned by client. And one of the things we talked about in the earlier segment of this program, the fact that the Copyright Office says that something that is made solely by AI is not copyrightable. The Patent Office says something that's made solely by AI is not patentable. You're going to be in violation of that rep and warranty if the output is solely generated by AI. And there have been advertising campaigns that have focused on the fact that the ads were created by AI, and undoubtedly there was some human intervention, and maybe that avoids running afoul of a rep and warranty like this. But there will have to be conversations about these issues with agencies and clients. And in a lot of cases, agencies will be operating under an MSA, and the time to have these conversations may be when a new SOW gets added, when there's new work that's added to the stream, or when there's a renewal of the agreement, or if you have a great business relationship, just in the ongoing conversations about how work product is getting created. And if a client wants AI to be used, that should be a conversation about what risks there are, and how those risks are going to get allocated, and whether any modifications to the agreements are going to be needed. Another one that concerns me in this space is the rep and warranty of no copyright infringement. 4A's has been beating the drum for 10 years or maybe more at this point about the risks associated with agencies creating apps and creating websites and having a won't infringe any IP rights rep and warranty that may pull in patent exposure that agencies didn't look for. I think everybody understands that now. But we also, if we're going to be using AI, need to be taking into account the risk that AI was created using training data that might infringe someone's rights. It's one thing for the AI platform, whose business it is to create an AI engine, to say, I'm willing to take the risk that it's a fair use, that it's a transformative fair use to scrape all of this information and use it in some kind of some kind of AI output, but is that a business risk that you want to take, or that you're prepared to take when you're making a rep and warranty to your client about it? So again, these are issues that we need to be aware of, things that we need to have conversations about. And it may be that there will need to be carve-outs from traditional reps and warranties to give added protection for things that agencies want to do and for things that clients want agencies to do. But agencies should be doing them under an appropriate allocation of risk, and not in a scenario where the agency is taking on all of the risk. That's not a fair balance. And you know, all as we all know, these reps and warranties are almost always backed up by an indemnity provision that says that the agency will indemnify, defend, and hold harmless the client against any claim that arises from a breach of any of these reps and warranties. So then you're becoming the insurer against the risk that the AI engine scraping of the internet to build its training database, that is going to be a fair use, and that seems like a big ask of any agency, and an unreasonable risk in I think most circumstances. So so that's sort of I think the most immediate circumstance in which agencies need to be mindful about how these risks are going to come into play, and I think also counsels that you're going to need to take some proactive effort to stay up on these things, that waiting to read about how the law shakes out, you know, an ad week after the law has passed might be a little late this time around. There might be too much you need to do and too many things you need to change in your workflow for that to be a practical approach to all of this. So that begs the question, you know, what should you do? What things should you be doing now in view of some of these risks? First and most importantly, you need to understand the technology. You need to understand which platforms you're using, how they were trained, how their output works, whether inputs to those platforms get shared out into a broader universe outside of your organization. You need to be exploring walled garden systems, as I'm sure most of you are at this point. But these are important aspects of understanding the technology. Training is going to be critical on this. You know, just because you have a walled garden system at the office and you're comfortable that information that you put into it doesn't go out into a broader universe of people and possibly breach confidentiality, that doesn't mean that your employees won't use their own ChatGPT or other engines and put client confidential information or company confidential information into them. So the training is really essential. The training, you know, has to be informed by understanding the technology and by having systems that employees can use. I think it's pretty clear that the just don't do it approach is a hard ask at this point, and probably not a practical one. And that giving some path for this outlet is essential in the state where we are. And providing that path, I think, of necessity, requires a conversation about what your use cases are. You know, what are the situations in which it's okay to use AI systems, which ones, and what are the circumstances in which it's not okay? And employees need to be really clear about that. That has to be part of onboarding. That has to be part of ongoing training. And we're seeing that now. We give those training sessions all the time. We do sort of train the trainer sessions, and then clients run them internally at that point, and sometimes we do periodic updates. But that's essential, and it's going to be ongoing, and it's going to change constantly. The sessions that we give now are very different than the sessions that we gave a year ago, and that is just going to continue to evolve. And even more so, as you know, following on Heather's presentation, even more so as the laws continue to evolve, and there are regulatory guardrails that get imposed that may be different than the business guardrails that you devised for yourself. So that's an essential part of all of this. it sort of goes without saying that in the context of this presentation that the rules vary among states and internationally. So you're going to need to be mindful of that. For agencies operating in a national framework, or for clients with customers that are across the country, you're going to need to figure out what the sort of baseline is. You're going to sort of have to go to the most conservative approach, because in most cases it will not be practical to geolocate and adjust your activity in relation to use of AI to limited geographic areas within the United States, although maybe you will be able to internationally, depending on who your clients are and what your agency is. But these will be things you'll need to think about. I gave the examples of some provisions that are common in services agreements. Review and update your services agreements. Your standard forms, hopefully you have already been updating them with an eye to how you're planning to use AI, or putting some placeholders for discussion with clients about that, but that needs to be happening. Likewise, with the agreements that you already have in place, most, at least a lot of the clients I work with, they have an understanding, at least the folks in the business affairs office or the CFO's office, whatever the line of reporting is, they have an understanding of which agreements were really terrible agreements that they were forced to sign because it was a lot of business. So pull out those agreements, the ones that you know are bad, and take a look at how these provisions might really put you at much greater risk than they did before, and start to think about how you're going to have those conversations with your clients. And my experience has been that clients are relatively receptive to reasonable concerns about these kinds of issues. They're not going to do a 180-degree turn on these things in terms of who has what liabilities, but you may be able to reduce some of them, or at least to show that you're being proactive about trying to manage some of these risks and being fair about them. Most important of all, you're going to need to work with counsel and experts on this. There's just too much information. As a practical matter, there's too much information for you really to process it in-house, unless you have an enormous law department. We have a lot of resources that we put at this in our government affairs group, in our technology group that Heather is part of, in our IP group that I'm part of, and there are just a number of touch points, and it's hard for any 1, 2, 5, 10 people to keep up on this. It's really a large group effort. So we thought it would be helpful to talk about how you go about finding people who can help with this. What are the things that you need to be asking your counsel, whether they have skills or capability around, and if not, how to think about finding counsel to supplement your counsel. So there are going to be internal governance issues. Most counsel should be able to help you with that. Most counsel should have a sense of how to help expand your internal policies, how to guide you on employee in education, and how use of AI relates to company principles. That is, I think, pretty much table stakes for most larger firms, or for the firms that are going to work for significant advertising agencies. But you'll want to draw on those resources. Privacy and security advisory. So because AI has such potentially strong implications in the privacy space and in use and handling of data, it may be that your traditional privacy and cybersecurity lawyers are a little bit overrun by circumstance now, and you should probably be having conversations with them about their experience as it relates to AI issues and how they're keeping in front of these issues. And skipping ahead to the fourth point here, whether they're involved in government engagement. as these laws are evolving, there are opportunities to shape them. And if you have significant clients that are impacted by one version of this legislation rather than another, there are still opportunities to become involved in that conversation, and working with your counsel to try to shape that is critical. And product strategy, where your clients' products are hitting the market, or where your product offerings as an agency in terms of the functions that you build into apps or into websites, how those work and how those use information are trickier to navigate nowadays, and finding counsel that has the depth that you need is something that is going to be increasingly important for you. So you want to understand how your firm has what resources your firm has to handle these things, in terms of number of personnel, in terms of where they're located. There should be people in DC working on these issues. There should be close hand in glove work between the people in the government group, the people in the IP group, the people in the data privacy and security group. The issues are interrelated and each bring particular expertise, and you should be checking to see that they're able to help you in a meaningful way on all of them. You should ask for references. You should, I mean, that sort of, it's an old piece of advice, but I would like to hear of a firm that I was considering hiring that they work with agencies that are bigger than me on these issues, or that they work with large technology companies on these issues, that they are up to date because they have to be, and ideally that they are involved in making the law on this, because that's very much a reality at this point. There are still opportunities to evolve the law, and it's an opportunity that we should not forget about or forego at this stage. So that is the bulk of the presentation on this. I see that some question and answers have come in, and I'm going to let Molly kind of drive that and make whatever decisions need to be made about which questions she wants to tee up, and then I always have questions for Heather, because Heather is so deep in the weeds on a lot of this stuff. So if there aren't enough questions for that, I know I'm gonna have some.
Perfect. Well, thank you both so much for kind of giving that great omnibus view of what is happening out there. To dive into some of the questions we've received. So the first one is, are agencies or affiliates running into any issue with the use of Microsoft Copilot? Is the use of Copilot internally without permission from all clients advisable if the agency maintains effective internal policy and has commercial data protection? Copilot terms dictate users must utilize the platform in a manner that does not infringe or attempt to infringe, misappropriate, or otherwise violate any of Microsoft's rights or those of any other person or entity. Our agency would like to ensure that we are in compliance, but do not think it's feasible to amend all of our contracts to allow for the use of generative AI in order to use Copilot internally. Thoughts? That was a lot.
It's a very good question.
Yeah.
As you're exploring using some of these tools, those are the questions you need to be asking. So kudos. I think that Eric probably has a better answer here, but I want to point out that anytime that you're exploring new technologies like this, you should make it really clear what it's for. And so I think that there are some uses of Copilot that in this case, you would want to just tell folks isn't in considered acceptable use under your own policies. And that might give you a little bit more leeway. There's some things that Copilot is good at, and there's some things that Copilot isn't. And maybe it's really good for creating calendar entries, but maybe you're not going to let folks use it as part of their creative process. And I think that might change the discussion a little bit. But Eric, as the lawyer, what do you think?
Well, I mean, this is one of those it is a great question, and it's one of those early in the life cycle of the technology questions, because Are you getting permission to use Grammarly? Are you getting permission to use Siri? Like, all these technologies are already getting used in many cases. You know, we haven't really thought to ask clients about it in that context. And are we going to ask them in this context? You know, I've been doing this long enough to have been around for the first dot-com boom, and you know, there was a category of lawyers at that time that called themselves internet lawyers, and you know, there are lawyers calling themselves AI lawyers now, and you know, now internet is just the pipes, and AI is just going to be the software. So this is going to be deeply integrated into everything we do in very short order. And permissions, you know, to use certain kinds of products or technologies, you know, I think are going to be irrelevant in some circumstances. I think the questions that are important are what the risks are of using the technology is. So, for example, if a technology restricts use of confidential information to a walled-in universe so that it can't get out into third-party territory, you know, that takes a lot of risk off the table. And I don't know, I struggle to think about what a client would care about as long as there's protection of confidential information at that point, other than output infringing rights. So, you know, I think the questions are less, to my mind, are less about what the applications, what the program is, and more about what's happening with the information and what is the technology being asked to do or create. And you know, I haven't heard, to answer the question more specifically, because I don't want to avoid answering the question. I haven't had clients ask me specifically about Copilot, but I have had lots and lots of clients ask about generative AI technologies generally. And I try to steer the conversations back to, you know, what is the concern for the client? What's the concern for the organization about the use of any particular technology? And then we need to drill down into how the technology works, or how the client's particular instantiation of the technology works.
And I think that that's actually, if I can jump in again, a really good point. I think Copilot and other tools like Copilot typically have mechanisms to architect the data in such a way that it's using the things that it ought to use and not the other things. But that does depend on using those features. And so this isn't just kind of a legal question or a policy question. It's also a technical question. As these technologies evolve, I think that those mechanisms will get more robust and easier to use potentially, but they do exist now.
Perfect. All right, the next one, and Heather, I'm going to direct this to you, and this is certainly something we've been talking a lot about at the 4As, but regarding the EU AI Act, are there any guidelines around what the specifics of what AI-generated content needs to be labeled? There's a spectrum of AI usage in generating ads, ranging from just resizing an ad to actually producing the imagery of the content. Is there a threshold for what requires AI disclosure?
Excellent question. And unfortunately, the way that the European Union writes laws tends to have more wiggle room and more interpretability than US laws. And that is to say that the AI Act has some high-level statements about any systems that create or generate what's generating synthetic audio, image, video, or text content is the exact phrasing. Any AI system that does that must label that output. I think that that's pretty vague. And it is a pretty good candidate for something that gets clarified as implementation begins. But right now, it's a very broad stroke. And to dig into that a little bit more, there's also a requirement that labeling be kind of more robust than just some pixels on an image. And there are in different contexts, that's going to apply in different ways. But frankly, right now, there isn't a lot of clarity, and it's something that if you have folks in the EU working with regulators is potentially worth asking. I will note that the EU AI office, which is being stood up right now as part of the AI Act implementation, will be doing a study on this and will be taking feedback and will kind of set the best standards and guidelines around what needs to be labeled and how.
Right. So more to be seen
Yes.
as with so many of these things right now. Okay, next one. Any thoughts on Adobe and their Gen Studio platform? They claim that it is ready for companies and agencies to use, but it doesn't seem like they have clearly covered off on some of the legal issues you've called out, mainly because maybe the rules are still vague, at least for the US-based work. Are you familiar with the platform to speak to this?
Um,
Go ahead, Eric.
I was going to say, it's tricky territory for us to talk about specific companies' products, and the degree of legal compliance or not of any of them. But I think it's fair to say that it's pretty hard to design any product, any software product, or any robust platform software product in a way that's going to be off the shelf, compliant with all laws in a space where the laws are not all written yet and are evolving quickly. So I think that regardless of what a company says about its readiness to deal with the legal context in which you might use the product, you're always going to have to be mindful of what the legal requirements are and think about whether the product is going to meet them. You know, as with virtually all products, they can be used in ways that comply with the law, and they can be used in ways that don't comply with the law. And it's going to be up to the user in each case to make sure they're on the right side of that. I think that's sort of all you can do, but that, you know, that goes to what we were saying earlier, that you're going to need to be more proactive on this than maybe you have been on a lot of laws for a long time. Unfortunately it's going to be a lot of work, and I guess the flip side is there is the opportunity for it to be a tremendous productivity enhancer, a tremendous source of cost savings. So the investment in it probably has value, but it's also important for risk mitigation. But there's just going to be a lot of work to get our arms around it and to stay on the straight and narrow. And there will be opportunities, as I said, to shape how the law unfolds. So you know, that this is a ripe opportunity, both privately with your agencies and potentially with clients, but also in groups, like through the 4As. You know, that part of the 4As mission is to help to evolve laws in ways that are favorable to the advertising ecosystem and to member agencies. And this is certainly an area where you know, I expect to see the 4As trying to nudge legislation when the time comes.
Most certainly. All right, one more here, and it maybe falls a little bit into what you were just saying, Eric, but what would you say is the best way to approach a client who is asking us specifically to use generative AI to cut down on production time?
We'd be delighted to. Let's have a conversation about what that looks like. And you know, there are risks that come into play. The reps and warranties in your MSA are probably not quite applicable any longer. Maybe the insurance requirements aren't going to fit exactly right. There are going to be a bunch of things you need to. I think the short answer to the client is yes, and I think the more robust answer is let's have a conversation about this, and you'll want to have your counsel involved, and if you are counsel, you'll want to make sure that you know you're touching on all of these issues and making sure that you document in some way how you all have agreed you're going to do this together.
Perfect. One more here. Should agencies consider using ChatGPT Enterprise versus the free version? Have agencies had any indication that a business version may be safer?
So I'll jump in there, and I'm going to answer in the general, although it does apply generally. Most of the time, the enterprise version of these tools has additional controls, has additional protections, and has different default settings than a publicly available tool. And so I generally, when I'm working with clients, do advise them not to use the free versions, not to use the publicly accessible versions for any number of reasons. But it is, if you are considering it, you should definitely look at what that difference is. And most of these websites will give you a quick rundown of what features the free version or the publicly accessible version versus the enterprise version has, so that you can make a really well-informed decision. And I do tend to think that those are, if you're going to use these tools, pretty compelling.
Wonderful. All right, we only have a couple minutes left. Eric, I know you had a couple questions for Heather. If you have a quick one, I'll let you use the time.
Oh yeah, well, so I mean, one of the things that that I think is worth touching on, and it's going back to the EU AI Act, because it's already enacted, and because we have a target to aim at, and that is, I think it's worth understanding what the risks are. Heather mentioned that. If you are offering a product or service that uses AI to European citizens, regardless of where you are located as an agency, or where your client is located, the EU AI Act is implicated. But what does that mean is the sort of follow-on question, and I think it's worth taking a moment to just touch base on what some of those exposures are, and why it's so important to make sure that you that you are giving some thought to compliance. And Heather, would you mind telling us a little bit about that?
Sure, let's start with some numbers. Similar to some other European laws, some other EU laws, some of the numbers involved, if you are found not to be compliant, are fairly staggering. It depends what you're not compliant with and how severe they consider that. But the numbers, if they consider it egregious, so for example, if you put a unacceptable risk AI system onto the market in the EU, that could be 7% of your global turnover. And that's really significant. I don't think there's anyone who would say 7% doesn't matter very much to me. They do cap that at 35 million euros. And for other less egregious compliance issues, for example, they cap it at 1% or 7.5 million euros. But both of those are very significant. And like other EU laws, it would also, you have the potential of going to court, getting an injunction, having regulators pay a lot of attention to you in ways that you didn't really want. And so I think that the very high level answer to that is it could make your life a little unpleasant.
Yeah.
Unpleasant indeed. All right, that
Good,
takes
for goodness sake.
Yes.
That takes us exactly to time. So Heather, Eric, I'm going to thank you both so much for being with us today and for sharing your expertise with our audience. Also, I want to thank everybody who joined us today for spending the time. As a reminder, the 4A's has a lot of guidance available to members on AI, so please feel free to reach out to myself or others at the 4A's if we can be of any assistance. And I wish you all a wonderful afternoon. Thank you.